Shall we come on side? The honourable member for Toronto-Danforth.
Thank you, Mr. Speaker. One of the concerns I continue to have is that the false impressions that are being left by the government in general, and with the current minister having to carry the can, apparently. I won't go further than to say that she is responding to the questions and others aren't. First thing is, the distinct impression was intended to be left. That's a very awkward way of putting it, but back in December, for 2 weeks, we were all under the impression that the government had decided not to appeal the Frank case, because the whole presentation of Bill C-50 was, we need this to implement the Frank decision, as if, we're complying. Constitutional judgment, we realize we don't stand any hope in winning an appeal. We're no longer going to fight against enfranchising all these Canadians who before now have been disenfranchised, so we're not going to appeal. Turns out to be totally false. Once we actually started probing, the government case continues. So there's no actual interest on the part of this government in enfranchising Canadians, and that should inform how we understand what they're trying to do with this bill. When they're forced by the courts to abide by the Frank judgment, this is how they're going to do it, and they're going to do it in a way that makes it exceedingly difficult compared to what the process used to be for citizens abroad. So it has to be put on record. The government is appealing the Frank decision, and that is part and parcel of why they are seeking to make it more difficult for Canadians to vote through this new bill, and why they do not want a lot of debate and a lot of awareness about the bill at all. The second thing is, our colleague has made a very good effort to indicate that somehow or other she's presenting it in a way that suggests there's some streamlining is going on here. A bunch of rules are being cleaned up, and the Frank judgment kind of spurred that analysis of how to make citizens voting from abroad more efficient and more secure and fairer and everything else. And the fact of the matter is, the single biggest change, there are 3 or 4 major changes, maybe the single biggest change in this bill, is that those who are abroad cannot begin the process of voting until after the writ drops. It's only at that point that they're now allowed to register. And then a whole series of steps involving the mail across the globe take place that creates a huge risk that they'll never get to vote at all. So the streamlining sort of subtext of this is absolutely inaccurate. So I think it's really important, Mr. Speaker, to know that both of the points I've made about the Frank judgment and what's actually going on in the judgment on that point speaks to why this government delayed so long in not bringing it back for debate because of the attention it would continue to generate, and now wants almost no attention, which is tied to the fact that it's set down for debate tomorrow, Friday, the day when the least attention is paid to bills in the House.
The Honourable Minister of State.
Thank you, Mr. Speaker. So just to start to set the context for my response to this question, I want to make clear to people watching this debate, when my colleague opposite is saying that Canadians can't vote, I want to really make sure that they understand what the context of the Frank ruling is. So in May of 2014, this particular decision through the Ontario Superior Court struck down the law preventing citizens from voting if they have been out of the country for more than 5 consecutive years and have no intention of returning. So that's the group of folks that we're dealing with how to deal with this particular ruling, and I want to make that perfectly clear to those who are listening. Now, in terms of the appeal of that decision, yes, our government has said that we are going to continue with the appeal, but we were also very clear with that all along this debate. So I also disagree with my colleagues' attestation or assertion that somehow this fact has been hidden. The reality is, Mr. Speaker, part of the role of government is to take positions on certain policies, which we have in the appeal of this decision, but also deal with the reality that courts' decisions provide. Because of this decision, there are certain ambiguities that I think need to be tightened up in our legislation, which is why this bill was presented. There's no reason why both of these things can't happen at the same time. So with regard to his particular point about time to register, I would note, Mr. Speaker, that right now in Canada we have a process for special balloting. So certainly I know I have friends and colleagues that they live outside of the country for a greater period of time, the snowbird type folks that we all know. When they go abroad and an election is called, they can register for a special ballot. Special ballot comes to them. There's already a procedure to deal with folks that are living abroad. So I think it's reasonable, since there are Canadian residents who perhaps haven't been as gone as for that long a period of time, that already prescribed to a process like this, that it could certainly work again for folks who fall under the category outlined in the Frank ruling. Again, so when we talk about streamlining, this isn't resetting the wheel. This isn't reinventing the wheel. This is about saying, look, we already have a precedent on how to deal with this with special balloting. Why wouldn't we make that consistent for those who fall under this ruling? So, the form and substance, again, of this bill is to provide clarity and consistency in terms of how we deal with voters who are abroad during a federal election. Thank you.